פישמן-אפורי, and she's assistant professor at the College of associate. Sorry.
I worked hard for it.
Professor at the College of Management Academic Studies Law School. The floor is yours.
Okay, so first, I think I broke it. Okay. There we go. So first, I would like to thank the organizers for inviting me. It's a great pleasure for me to be here. I'm wrong? Okay. No, it's appropriate for associate professor. Okay, so I think it's clear that the function filled by public libraries in providing access to electronic materials is of great importance to various values such as progress, furthering progress and access to knowledge, and in turn it promotes a democratic and a liberal society. Even so, unfortunately, e-libraries have become the source of a broad controversy. The debate thus far has focused on two topics we just heard about. The first is on orphan works, and the second one is on the Google digital library project. These two subjects of orphan works and the Google project are closely related in the view of the attempt to allow a massive use of materials in cases that there is no contractual relation between the copyright owner and the source provider or the end user. It remains to be seen, however, how the doctrine will evolve in light of the recent court decision rejecting the Google settlement. I would like to address a different issue, which is an important one, which I would say is suffering from a lack of public relations. And the question is how to allow the broadest possible use of electronic materials provided by public libraries in cases where there is a direct contractual relation between the library and the material provider, namely the publishers. Libraries acquire licenses for eBooks and for databases such as Lexis, and the contracts usually contain restrictions on use. Libraries in general, and certainly small libraries in small countries like our libraries, have no possibility to negotiate these contractual terms. And I think the time has come to impose regulatory controls upon these restrictive copyright contracts, given that they prevent uses permitted by law, and therefore, of course, hinder the realization of the potential of e-libraries and the ideal of the information society. I think I'll skip the theoretical part with respect to the importance of public libraries as the offline most important intermediary. I think all of us are familiar with the topic. I just want to mention two important issues for the rest of my talk, which is first that major publishers have gained uncontrolled and unlimited powers through the copyright they force upon libraries. And I think the question is how or by what means this market failure of the copyright contracts of libraries should be treated. I'm sure that all of you are familiar with the type of contract I'm talking about. However, in order to convince you that the problem is very real, I would like to give some empirical data and present it to you. In this context, two surveys outside of the U.S. were mentioned. The first one is quite known. It is the Australian report on copyright and contracts prepared in 2002 by the Copyright Law Review Committee, which is kind of a specialist advisory body for the Australian government on copyright issues. The report, by the way, is of course available online. The report reviews many contracts assigned by academic libraries and describes the restrictive clauses. The report concludes that a very substantial number of license agreements contain terms or conditions which purport to override or modify copyright exceptions. Some examples could be given. For example, restrictions on users printing or downloading copies or parts of copies of the resources, which is overriding the section in the Australian Copyright Act, which is allowing a fair dealing for purposes of research and study. Another example is restrictions on libraries performing interlibrary loan or document supply, which is overriding the Australian provisions allowing the reproduction and communication of works for users. I think it's highly related to the first sale doctrine that Paul has mentioned earlier. And of course, there are many more other examples. I'll just skip. Here are some concrete examples of such restrictive clauses which are extremely problematic. The Australian report mentioned the license for an online encyclopedia which provided that this service, there's a quotation, this service is protected by copyright laws and accepting a single copy for personal use, no extract may be copied, reproduced, or distributed. It is clear, though, that the distribution of extracts is essential and I think is also common for academic purposes. Another extremely problematic clause is an example from an agreement with a U.S. information provider. It's a database provider, which provided that the databases, of course, are copyrighted. Customers shall not duplicate, distribute, sell, etc. The databases or the information contained therein in any form or medium and so forth. This, of course, is extremely problematic clause. In Israel, a series of court decisions have clarified that the information contained in databases, being data, is of course not copyrighted and may be used freely. Restrictions upon using data included in databases for academic purposes contradicts the goals of promoting research and progress, and I think also undermines the foundations of copyright law. Another report that should be mentioned is less known, is more recent. It is the one prepared by the British Library in 2010. We have heard the representative of the British Library. The survey is, of course, also available online. The British Library checked 100 contracts that it had signed, and many of these contracts undermine acknowledged exceptions or permitted use in the English Copyright Act. It should be mentioned that the English Copyright Act in any event is not so generous, I would say, with respect to permitted uses or exceptions to copyright. The report concludes quite similarly that the British Library contract revealed that 90% undermine the public interest, exceptions in copyright law agreed by Parliament to foster education, learning, and creativity. So I think the problem is clear. The question is, what is the solution for this problem? And since the problem of restricted copyright contracts actually affects, I think, the function of e-libraries, the solution should be the interference with the freedom of contract. I think there's no other way. There is an academic debate over whether recognition should be given to a contract that circumvents exceptions established by copyright legislation. However, there is a growing understanding that such exceptions should be interpreted as mandatory, namely jus cogens. Niva has written a lot about it. I think other scholars in the room have stressed the point too. Therefore, the debate should be focused on the form that such interference should take place. How should we interfere with the freedom of contract? One possible way is, of course, through uniform contract law or consumer law. A better choice, in my view, would be to directly confront the problem of restrictive contracts via the copyright law in order to create a more comprehensive solution. Thus, there is a need to introduce a special clause in Copyright Act which would safeguard libraries from restrictive contracts. I think that despite the debate whether, generally speaking, a copyright exception should be interpreted as mandatory or not, it would be much easier to achieve a consensus on the specific and narrow need to protect public e-libraries. Public e-libraries, which are non-profit institutions, represent actually the core public interest in promoting the information society. In other words, politically speaking, it would be much more realistic to start with a codified clause restricting the freedom of contract with respect to the narrow interest of libraries for providing e-materials. It is very important to stress that there is no legal impediment to the codification of a clause restricting copyright contracts, and the impediment is more of a political economic one, I would say. 3 countries, as far as I know, thus far, Ireland, Belgium, and Portugal, have already codified a general rule preventing the practice of restrictive contracts. I've checked each one of the laws, and it indeed includes such a general rule. And the British Library, by the way, has proposed the legislation of a similar rule in the UK, of a general clause forbidding circumventing exceptions. Moreover, in Europe, there are at least 2 European directives, the database and the software computer directives, which contain clauses forbidding specific restrictions in contracts. So there's no legal impediment. It is allowed according to the TRIPS and Berne Convention. The problem is more a political or economic one. Thus, since the problem is a political one, I think the question is how to promote specific legislation concerning mandatory exceptions for public libraries. And I would like to propose here a framework appropriate for this goal of promotion of this type of legislation I'm talking about, and it is a public international law, and more specifically human rights concerning cultural rights or cultural values. So, just a little bit about the human rights vehicle. The tight connection between human rights and IP norms is gaining increased attention in recent years. It is also already acknowledged that IP rights should be restrained in order to promote values protected by human rights such as freedom of speech, access to knowledge, or participation in cultural life. The public library plays an essential role in promoting these values. Therefore, a codified norm according to which a library's exception should be mandatory could be a first step towards solving this restrictive contract nexus with a smaller degree of anticipated opposition, I would say, and I hope I'm not too naive about this point. Some laugh, well, the publishers. Furthermore, if such norm would be codified in an international instrument, I think another advantage would be there will be another advantage, which is it will promote a standard clause that will overcome serious problems of choice of law. Which country's law will govern the restrictive contract? So an international instrument can help a lot in this matter. Potential legal levers may be founded in UNESCO's different legal instruments. UNESCO is extensively engaged in the promotion and development of public libraries, and more specifically in promoting the operation of e-libraries, which are a significant tool for realizing all the values of access to knowledge, ATK, dissemination of information, and so forth. For example, in UNESCO's Declaration on Cultural Diversity, it was stated that one of the objectives that should be achieved is the, and I'm quoting, encouragement of digital literacy, which is enhancing the effectiveness of educational services. In that regard, a fairly new UNESCO convention should be mentioned. It's a convention launched in 2005. It is the UNESCO Convention on the Protection and Promotion of the Diversity of Cultural Expression, a very long name. And this new convention, fairly new convention, is an attempt to answer the need to accommodate national diversity vis-a-vis the framework of the international agreements such as the TRIPS and Berne, as we just talked earlier. I think it was an initiative led by Canada opposing the U.S. Control over the TRIPS agreement. The convention proposes to promote a fairly new doctrine called cultural governance. What is cultural governance? Just as there are rules of corporate governance which promote fairness and morality in the conduct of commercial firms, there is a similar attempt to develop notions of fairness and morality in the conduct of cultural institutions such as museums, theaters, and libraries. As to the convention, 116 countries are a party to this convention, including Canada, of course, and the European countries, Germany, France, and I think all the European countries. Unfortunately, 2 states have objected to join, USA and Israel. Yeah, so I was trying to figure out why Israel refused to join, and I couldn't find no material about it. I asked for documentation. There was no one to answer. One of the convention's most important rules is that countries are sovereign to adopt measures promoting cultural expression within their territories. Moreover, it's a very sophisticated principle that the convention stresses. It stresses a mutual supportiveness principle with other treaties. However, at the same time, it insists that the convention must not be subordinated to these other treaties. Namely, in other words, countries are free to adopt appropriate measures to promote diversity of cultural expression and are not subject to Berne and TRIPS agreements. 2 minutes, okay. However, I won't refer to the question of the consequences of breaching the TRIPS obligations. However, as I've already mentioned, in any case, national legislation with respect to mandatory permitted uses is in line with the TRIPS agreement. The convention also specifies different ways by which such measures to promote the diversity of cultural expression could be adopted, including enactment of regulations for fulfilling the convention's goals. In that regard, a special clause should be mentioned. Article 6 to the convention enumerates particular measures aimed at encouraging non-profit organizations as well as public and private institutions to develop and promote the free exchange and circulation of ideas, cultural expression, and cultural activities. I think that such framework, Article 6 of the Convention, can serve as the initial basis for establishing regulation for public libraries forbidding restrictive contracts. I think we have the legal lever or the legal anchor for such legislation. So just to be hoped that the human rights framework or any other framework will ensure that the problem of restrictive contracts will not be ignored anymore. That's it. Thank you.